Welcome to MP Access. I'm Gina Galusha, Executive Director of 5-Star Institute, and I'm here with Jeffrey Fraser from A Law. He is a bankruptcy attorney. He serves on our publications committee for League, and he really just is a good dude. So we're excited to have him here today. Tell us a little bit about yourself.
Well, thank you for the compliment. Very humbled by those words. Being a good dude is something that I take that very kindly. So thank you for that. I've been now practicing now for 15 years. I've been with A Law now for 12 years, so the bulk of my career. And at A Law, we represent mortgage servicers and creditors, and then we've expanded to all types of creditors, auto lenders, things of that sort. And I oversee our firm's national bankruptcy department. It's one of those things where I started bankruptcy right out of law school because of the nature of the time and the climate in which that I came through. It was the mortgage foreclosure crisis in Florida. And essentially there was so many bankruptcy jobs because, foreclosures were everywhere between Miami, South Fort Lauderdale, West Palm Beach, and then up into Orlando and all of the entire state of Florida. So there was a lot of jobs for people fresh out of law school. And as a lot of people say, I just never left it. So I'm here now, and then I've been with A Law, a great group of people, and pleasure to be here.
Glad you're here. What about bankruptcy law has kept you, right? Everybody can have a beginning to their career, but not everybody chooses to stay.
Well, in an interesting way, every time that, not just me, but a lot of people are asked that question, a lot of people say they fell into bankruptcy. And because it's not something that, you go to law school and you envision that you're going to do it. But it's like you don't go to law school and say, I'm going to be a bankruptcy attorney. Unless, you have a family member that did so and you want to take over their practice or something like that. But for me, I can tell you a very, very short anecdote. When I was in law school, they preach to you after your first year, you want to get your best law firm job right after your first year, and the dream is it's a summer associate position. Then they come back and they hire you on the next year, and then the next summer, and then they hire you to be an associate, and then everybody lives happily ever after. So I did get a summer.
It's like a Disney story, but
exactly,
different.
Exactly, and I did get a summer associate position in the summer of 2008. However, because the economy was starting to tank, they had to rescind that position a week before I started. So I scrambled to the career development office at the University of Miami, and I said, "Listen, I told her the story. She felt bad, and I wasn't discouraged. Although that was my thought process at that time, that it didn't matter where. I just wanted to be in a big law firm, and then I'll figure it out thereafter. And I said, I just need to put something on my resume. So what I did is I asked her, I just need to go anywhere. Just something that after my first year of law school, I have something to say that some legal experience to get me started. And she found a bankruptcy judge in Fort Lauderdale. And that was the first time I ever even heard of bankruptcy law in my entire life. And I never left. And that's a long way of me starting to answer your question, is that I don't know if you could detect, my personality is kind of very relaxed.
Yes.
I like, intellectual work. I like to do things that are, I love the law. I love, making legal arguments, but I'm not really a confrontational type of person. Bankruptcy is more of a collaborative environment as opposed to adversarial. The goal, the counterpart of my firm does foreclosure. So foreclosure law, the whole goal of it is to, you start a foreclosure action and you retake the home based upon a default, which is fine. That's the way that the law works. But sometimes it becomes combative and adversarial. And I'm not saying that bankruptcy doesn't at times become adversarial. However, the main goal of bankruptcy is to be collaborative, work with all the entities that are involved. We're all governed by the bankruptcy code, and then thereafter, you guys could come together, have an agreement that's effectuated by all parties. And really, a successful bankruptcy for everyone is not, the bank, quote unquote, winning or getting relief from the automatic stay, although we do that. But the real goal is to just make sure that the system was used properly. All the parties were treated fairly, and that just kind of coincides with my personality and my relationship. So I don't know. There's probably other areas of law out there that can do that, but I found a great one, so I don't want to leave it.
Right. If you're comfortable and you're knowledgeable.
Try to be.
You are.
I've been doing it a little while, so it'd be bad if I wasn't. Didn't have some sort of experience in it.
You mentioned that you like kind of researching academics. You write a lot of articles.
Yeah.
You write articles for us. I know you write articles for other folks. I see it on LinkedIn. And you write good articles. What are you working on now?
Right now, not currently working on an article.
Well, tell us about your most recent then.
Okay. Well, I guess I could say the most recent article that I had was one that I worked on for another publication. And the way that what triggers me to write an article is, and by the way, I love to write articles not just to get out there and be published or anything like that, but when I was in undergrad, I was an English minor. And I was a psychology major and an English minor. But
I approve of those choices.
Yeah, and it wasn't, and I didn't realize it until right before I graduated, but I think I was about one class away from an English major. And it wasn't even intentional. I just really like English. I like to write. I just like the practice of writing. I like crafting and creating my own work. And that's why I write a lot. But as it relates to the last thing that I wrote about something where there's a case out of the Supreme Court from many years ago, Johnson v. Home State Bank, and essentially it has something to do with a broad definition of what a claim is. And because, the way that the court ruled in that particular case, it's not really coinciding with how a lot of courts have actually used it. The courts have kind of expanded that language a bit to include different types of claims. And I understand the perspective because, interpretation is everything, but I think you could very easily interpret it into a different way. And that kind of took me down a rabbit hole of trying to do some research on different types of claims that fall under the umbrella of Johnson and stuff like that. So that was, I think, my most recent article that I had published, and I really enjoyed it. As far as anything else that I have coming up, nothing really, just kind of keeping people abreast of different rule changes that are occurring. Bankruptcy Rule 3002.1 being amended.
Doesn't it sound like some kind of scientific something when you say it that way?
Bankruptcy Rule 3002.1?
Yes.
Well, yeah.
Star Wars-y, maybe?
It does. Well, if you think that's pretty Star Wars-y, you should hear the names of the new forms. And I don't have it in front of me.
Dang it.
I don't have it in front of me, but one thing for sure is that I'm assuming, later on in the next year, 2 years, or however, it's just going to roll off the tongue. But they're very crazy. And correct me if I'm wrong if I say this, but I think one of the forms name is like Form 410C13 M1R, stuff like that. I don't know why they would have that much just to say a response to the debtor's motion to determine status, but they found it fit. The Rules Committee found it fit to name them those things, and that's who they are. But while the name is unique and kind of difficult, I think it's going to be difficult, or it may not be, because there's been so much preparation for the rule changes.
They gave a good amount of time.
Yeah,
right? A lot of forewarning.
They've been talking about this for years now, probably 2 years, maybe longer than that. And I think because there's been so many different versions, rule proposals, amendments.
Oh yes.
A lot of different organizations got together in their own different silos and reviewed the rules, created their own comments, their own concerns, and what I like to think is that the Rule Committee listened to those comments and concerns. Obviously, they didn't adjust everything, but they took them in mind. And when it's taken in mind, at a minimum, when it comes out into practice and how the rule will be applied, I think that'll be considered.
Comes back to your comment about collaboration, right?
Yeah, of course. And a rule is a rule, and you have to follow the rule. And these rules are relatively clear. They could be clear. I always think that there's room for improvement, but I think they did a decent job of making it clear enough. It made it definitely is going to make it a little bit more difficult on mortgage servicers as it relates to compliance and getting things in on a timely manner, and the spontaneity aspect of the quote-unquote anytime motion, where a debtor or a trustee can file this motion at any time during the bankruptcy case to kind of, I don't want to call it have a gotcha moment against the servicer, because that's clearly not what the intent of the rule is. But it can come to light where it lends itself to the potential for abuse. So I'm not going to say it's abusive because it's not even implemented yet. But, when you have something that there's no limitations, and it could be done at any point in time, and it's against a mortgage servicer, and your debtors are already in a position whereby they might, be on the defensive on their mortgage loan, whether, things don't look right, the statement doesn't look right. They could pull the trigger on this motion whenever they want. So, but we'll see. I'm an optimistic person, so I think everything will go well.
That's good. What is that, plan for the best, expect the worst?
Yeah. Hope for the best, expect the worst. Or is it the other way around? Expect the best. Hope for the best, expect the worst. Yes.
Plan for the worst.
That's what it is, yeah.
Yeah, totally. So if you wanted to tell listeners anything about that rule, what would be your big takeaway other than the anytime?
Just being aware. Everything, it's just, as far as for the listeners, and I'm assuming the audience would probably be people in the mortgage service industry and things of that nature. I don't think I have to say much of anything. Because they know. And I think not only, I think there's been so many panel discussions on it over the course of the past 2 years. Legal League themselves had a great panel, I believe it was in December of 2024, with phenomenal people in our industry, always great people that are in the, I'm selfish to say, or maybe I'm biased, but I think everybody in this industry is phenomenal, because I think it says something where a lot of the people that I've been around, or my closest friends, or people that have been my colleagues now for well over a decade, because people stick with it. They stick in the industry. And I don't think they do it because they're stuck in the industry or anything like that. I think because, they're good at what they do, and I think it's meaningful work.
Tell me more about that. What's meaningful about it? Like, when you've had a really good day, what happened that day?
Well, I think I don't go to court as much as I used to because of my role with the firm now, but I still do go to court. But I think back, let's call it 10 years ago, we'll say 2015, 2016, whatever the case may be, where I was in court probably at least 2 to 3 times a week, and that was kind of the byproduct of the mortgage foreclosure crisis, trickling into the bankruptcy world, where all of those loans were defaulted. People were starting to get to the end of the line on the foreclosure case, so the next step is bankruptcy. So our calendars were very, 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 very full of people. And this is my long way of telling you what a good day would be. You work with great attorneys, even though they're on the other side. Again, the collaborative nature. But, taking it back to the answer of meaningful, right? There would be instances where I would be in court, because by the nature of Miami, Fort Lauderdale, West Palm Beach, it's volume. There's a lot of filings there. So just based upon the percentage, a large portion or a decent portion of those would be pro se litigants, people who can't afford an attorney or don't want an attorney for one reason or another. And a meaningful time would be where you see someone, a good faith debtor, who's not trying to abuse the system or not trying to, get over on anyone and not wasting anybody's time, but generally fell on hard times. They can't afford an attorney, but you can see in their case that if they move around this, that, or the other just a little bit, they can have a successful bankruptcy. And I enjoyed those moments, without breaching any confidentiality of what I did or what my role was supporting the bank. I would just sitting outside the hallway with the pro se debtor, looking at their case and saying, "Listen, I know," and they're frightened, they're scared.
Right.
They think I'm there to take their house. They look at me as someone that's going to take their house, even though I'm not that large a stature. But that's the representative.
Right.
That's the impression that I would give off. But it's like you disarm them. You talk about, listen, we're here to see if the property can be saved based upon all the factors that you have in your schedules. How much what your income is, what your expenses are, and essentially how much do you owe my client. And they're spazzing out, they don't know what to do, but you reorganize it here, and they're like, well, I can do that. Well, I'm like, well, sounds good. Then let's walk to the judge and say what the next steps are. And judges appreciate that, because then judges appreciate it. They see what you're doing. They see that you don't have to do that, but you should. And bankruptcy is uniquely designed for moments like that, because you have the ability to impact people who aren't even your client, but at the same time, while not prejudicing your client's rights at all. So, you can't have anything better than that, where you can make everybody happy.
It's a win-win-win-win-win?
It's a win-win-win-win-win. Yeah, exactly.
I love that. Okay, now that you've transitioned to more of a director role, what would you say is a good day?
Well, I guess my role, I guess you could call me a director, or I'm a partner over our bankruptcy practice, but I still do work. I still work files. I still go to court, but for a good day, I really enjoy. I enjoy coming to events like this where you can take the knowledge and expertise that you have and kind of deliver it out to other people. But also, I love the fact of a part of my role as a head of our department is when we have someone new into the bankruptcy world, regardless of the state. That's another wonderful thing about bankruptcy. It's federal law. So each state has their district nuances or state nuances in one shape or another, but it's federal law. Every state has to be governed by the bankruptcy code first and foremost. So what I love about it is that I could take on a new associate. I could take on someone new to bankruptcy, like watching a new associate progress. Me eventually, slowly giving the baton back to them is something that I love to do. Bankruptcy is unique in the fact that, as I was saying earlier, I love making legal arguments. That's like one of my favorite things to do. And you're not imprisoned to one state. You can, although some of it is not binding, it's just persuasive as opposed to binding in your whatever district, it's 100% applicable for you to give it a shot, because you're dealing with the same code provisions. So, you could cast a wide net, put things together and have creative arguments. And I love creative arguments. And that going back to what you had asked earlier, that's a part of why I like writing too, because most of what I write comes out of issues that give me not either concern or irritation, where I just don't like the way that this is being applied, or I don't like how that court's ruling was. So it's like my outlet of telling you why it's not so great or why it could be better, and I could do that research. So it's almost like I could kind of have my own say in certain code provisions or certain court rulings that don't seem to go the right way. Obviously, nothing that I say is binding, but it's a perspective that can be shared.
Right. So creative, persuasive problem solving, both in writing and in bankruptcy.
Yeah, exactly. I think, if I've sold bankruptcy, right?
Yeah,
I
basically.
I try to.
It also sounds like, and maybe I'm biased in this way, you're a really good teacher and coach,
I try to be. Yeah, I
enjoy
love
it.
It's because I enjoy it. Mm-hmm. I enjoy people. If people are coachable and just are receptive to learning, there's nothing I enjoy more, because I enjoy it. So, might as well have someone else to enjoy it with. And especially if they're, working for our firm, we all, I enjoy getting that work done, and I enjoy that this person can now get that work done. And I love to teach, give workshops, all of those things, because it's fun, it's something that has a lot of worth, and it's meaningful. And it's the content of the code teaches itself.
Oh, interesting. The content of the code teaches itself.
Yeah.
All right. What about what you're seeing in the industry? What are you seeing in terms of volume right now? And is the volume different? Are there new things coming through? Or is it about the same that you've seen in the last couple of years?
Well, courts I think filings are ticking up a bit. And sometimes I like to say that it's regional, because it's different factors cause bankruptcies in different parts of the country.
Right.
Like, for instance, when I got into bankruptcy, we had a massive mortgage foreclosure crisis. And while there were foreclosures going on all over the country, it wasn't as bad as it was where I am. But as an industry, filings are steadily ticking up, which is good. But, there's different factors of why it's ticking up. A lot of it is unsecured debt, credit card debt, and things of that nature. So one thing that I'm seeing is that we're getting a lot of referrals for proofs of claim and things of that nature where the loan is current. So that means that we're filing a proof of claim because we have to in a Chapter 13 case, but we're filing a current or near current loan, which means that it's not really the mortgage that's triggering or causing the bankruptcy to be filed.
Right.
So it's one thing to keep an eye on. And then, we'll all have to see how, everything wiggles itself out. Whether it's, more unsecured debt, more credit card filings, and if that leads to, more filings.
Right. Yeah, we heard that kind of across the board in terms of the excessive obligations, the rise in taxes and homeowners, and all of those things are really the issue. It's not the mortgage payment that they went into expecting, prepared for, etc.
Right.
The other factors.
Yeah, and then, you always have those traditional factors in life that lead to bankruptcy, because while we're in the mortgage industry, and we focus on that being the cause, because that's, the entity that we're representing in the case, there's just so many different factors that lead a person to bankruptcy. And, I've been doing some studying recently about elder law and different types of, like, where we have a lot of people being duped recently, because there was always a problem with, elderly debtors and being susceptible to, scams, whether like a romance scam or a get money quick scam and things of that nature. But we're seeing a lot more lately because the enhancement of technology, generative AI, where you don't have to be elderly or incompetent or anything like that to fall for these scams. And those are other factors that are leading to bankruptcy. Different components, like also with the elder law, where you see you just healthcare issues, people who are living on a fixed income, where whether it's Social Security or something like that, and you don't kind of take it for granted that if one shoe drops incorrectly for that individual that's on a fixed budget, everything falls out of place.
Right.
And then so you're
dominoes.
going to need help from the bankruptcy court to address that. So,
Right.
And then you have other factors like, divorce and things of that nature. health issues. And
things you don't plan to ever happen.
Correct.
Yeah.
Correct.
I hear you on the AI and tech. My son the other day, he sends me a snapshot of text he got that's like, you owe tolls. And he's like, Mom,
Right.
What do I do? And I'm like, honey, you do nothing.
Right.
That's a scam.
Right. And it just, it's just a function of the world.
It is.
Yeah.
And just getting to know kind of what is the new thing to avoid or understand or totally. Okay, so anything else I haven't asked you about that you're really passionate about, you really want to share, talk through?
I guess, everything, I guess at this stage, in life, I have two kids. I have a 10-year-old and a 13-year-old and a wife, of course. And, between that, between what I do with work, between working with my family and all of my kids' activities and things of that nature, there's just every moment is taken up. But I think that's a beautiful thing, though, because it's exhausting. But the fact that I have all of these things that are taking up my time, but I love them all. None of them all of them could be tiring, but they're all rewarding. So it's a certain stage of life where you're doing a lot, but a lot of it is rewarding. So that's something that I'm, incredibly grateful for and thankful for.
Your life is full.
Yeah. Yes. My
That's
cup
good.
runneth over.
And time is short.
Yeah. As am I, right?
All right. Well, thank you so much for joining us.